Breaking leaked video of Trump talking about Greenland to the rest of NATO.
No. No.
Okay.
He says, Alyssa, well, the governor's response referenced a number of things, going after Mark Kelly. He says Alyssa Slotkin, Jerome Powell, but he also mentioned what Matt Finn mentioned in his reporting there. He says the only person not being investigated for the shooting of Renee Good is the federal agent who shot her. So is the FBI conducting an
Illuminator, thank you for giving subs and kick chat, buddy.
Investigation into that agent, into the shooting? What can you tell us about that?
Stop. I understand that OBS might have some built-in driver or API thing to detect it, but your computer doesn't have a driver to know what the device is. Oh, that could be it. I know that I can't have it open on OBS and other things at the same time, obviously. Okay.
Will it be made public?
Look, what happened on that day has been reviewed by millions and millions of Americans because it was recorded on phones when it happened. Okay, the civil rights, the Department of Justice, our civil rights unit, we don't just go out and investigate every time an officer is forced to defend himself against somebody or putting his life in danger. We never do. That has nothing to do with what happened in Minneapolis. There are over 1,000 shootings.
Wait, we never do? Or we don't always? Or that it seems like we switched answers up there. What?
Public.
Look, what happened on that day has been reviewed by millions and millions of Americans because it was recorded on phones when it happened. Okay, the civil rights, the Department of Justice, our civil rights unit, we don't just go out and investigate every time an officer is forced to defend himself against somebody or putting his life in danger. We never do. That has nothing to do with what happened in Minneapolis. There are over 1,000 shootings every year where law enforcement are put in danger by individuals and they have to protect themselves and they have
1,000 with federal agents where they kill 1,000 people a year, or what? What are these numbers? We're using a capture card or connected via USB-C? USB-C. And I believe that the base resolution of the camera coming in via USB, I think, is only 1080p.
A lawful right to do so. The Department of Justice doesn't just stand up and investigate because some congressman thinks we should, because some governor thinks that we should. We investigate when it's appropriate to investigate. And that is not the case here. It wasn't the case when it happened, and it's not the case today. If circumstances change, and there's something that we do need to investigate around that shooting or any other shooting, we will. But we are not going to bow to pressure from the media, bow to pressure from politicians.
Oh, it's the 6K camera, sorry. The Blackmagic Pocket Cam 6K.
And do something that we never do. Not under this administration, not under the last administration. And so, no, we are not investigating. And if there comes a time when we need to, we will, but it's not now.
Is there some type of...
Is there context to this? Did she ask if they're like investigating his background or what?
Well, the governor's response referenced a number of things, going after Mark Kelly. He says Alyssa Slotkin, Jerome Powell, but he also mentioned what Matt Finn mentioned in his reporting there. He says the only person not being investigated for the shooting of Renee Good is the federal agent who shot her. So is the FBI conducting an investigation into that agent, into the shooting? What can you tell us about that? Will it be made public?
Look, what happened on that day has been reviewed by millions and millions of Americans because it was recorded on phones when it happened. Okay, the civil rights, the Department of Justice, our civil rights.
Hold on. People looking at a cell phone video is not the same thing as an investigation. People watching a cell phone video is not the same thing as a formal process by which you take a totality of the evidence and you have a trained prosecutor who is familiar with the statutes that may or may not have been broken, ascertain whether or not a crime was committed. I have no fucking idea how many times this guy's head must have been slammed against a wall or he was dropped as a baby to utter something so unbelievably, unfathomably fucking stupid. I don't know. I don't know what happened to this guy early in life. Maybe there needs to be an investigation on him for abuse or something. What an unbelievably insane statement. I don't know if there are law enforcement people in here. My guess would be that every single time there's an officer involved shooting, there's probably always some internal process by which you clear it. Even if nothing was wrong, even if it's like the most obvious thing in the world, that'd be my guess. There's always some way internally to say, oh, we did it. Like, an investigation doesn't have to mean that you arrest somebody and you charge them with a crime. You go. That doesn't have to be. It could be as simple as there were 10 different videos taken by, it could be cell phone footage, and it's like, oh, they were so obviously he was in the right. Like, we did a preliminary thing, we looked over it, it's like, we're not, yeah, he's clear, right? That's a phenomenal statement to me. What? Okay. What is this?
Hello? Yes, I'd like to speak to Congress, please. I'm on hold. But I'm trying to reach Congress on behalf of the Kingdom of Denmark. Now, my first language is Danish, but I figured I'd do this in English since I know how some of you Americans feel about people who speak foreign languages.
You have to speak English.
Anyway, the reason I'm reaching out is the northern part of the kingdom, namely Greenland, the world's largest distraction. The world's largest island. But listen, we here in the Kingdom of Denmark are getting a very Venezuelan vibe about the way the American president is talking about us right now.
We're going to be doing something with Greenland, either the nice way or the more difficult way.
So, what do you do when an employee goes rogue? Well, what I've learned, mainly from watching American TV shows, you ask to speak to the manager. And in Trump's case, that will be Congress. I mean, they can control the budget, they can hold investigations, they can even fire him. But they seem to be sleeping on the job.
Mr. Moore. Mr. Moore.
Hence my phone call. But while I'm on hold, maybe we can talk America? To start, let's look at a map. This is Greenland.
And before President Trump says, he's asking the U.S. citizens to consider what the president's doing, he's basically calling for an assassination. I can't believe, when we're just going to skip it because it's just one of a billion stories, that that Fat Seth or whatever, what did he do for Mark Kelly? It's not a court martial. He's revoking his retirement or something for that video that he made. I thought we had a First Amendment. I thought this was America. What the fuck? Unbelievable. Unbelievable. Revoking his rank, which would affect his... Isn't your retirement based somewhat on the rank you retire at? E3, E7, 5... I don't know what the fuck the letter number things are.
50,000 Greenlanders live there, and it's not green at all. It's white. It's all white. Maybe that's why that Stephen Miller guy loves it so much. This is Denmark. Almost 2,000 miles away. 6 million Danes live here. We do minimalism. We do Lego. We do hygge. We do the fat shot. That's us. Now, Denmark and Greenland are not the same country, but we are in a relationship. We share a king, but we have individual governments. We are very different, but we make it work. To put it in American terms, we're like Trump and Melania. We're formally together, functionally separate, and both pretending it's very normal. America and Denmark actually go way back.
Out of curiosity, what's the blackboard behind you with the places for letters? It's called a vestiboard.
We usually follow blindly whenever you guys feel like invading a country. We did it with the Gulf War, we did it with Afghanistan, we did it with Iraq. Coalition of the willing.
We will lead a coalition of willing nations to disarm him.
We were the willing. But this time, we can't help you. Because you're talking about invading a country that we already invaded. Look, we already know how colonialism ends. We've seen this film before.
India in revolt. Protesters smoked out by the police.
Here's why invading Greenland, the easy way or the hard way, would be bad for America and for the world. I think I need some fresh air. Danish missionaries invaded Greenland in 1721, slowly taking over the country. And for 200...
Hey, just checking. Are the groceries cheaper yet? What the fuck did we elect this fucking retard for? Why the fuck are we having foreigners making videos about why we shouldn't invade our fucking NATO allies? What the fuck are we doing in this country right now? Hello?
50 years, we did whatever we wanted to them. Basically going full colonial on them. Even in the 20th century, we were inserting IUDs into Greenlandic women to limit the population. We were separating Greenlandic children from their families, sending them to Denmark. Horrible stuff. We even let America build military bases in Greenland. During the Cold War, you guys had 10,000 troops based there. You even crashed a B-52 carrying 4 nuclear bombs there in 1968. Remember?
The hunt is on to locate the missing nuclear weapons.
So, what did we Danes learn from the past couple of centuries? Well, the obvious. No population is going to be happy with a foreign government ruling over them. The Greenlanders hated us for centuries. Some still do. So Trump invading Greenland is not going to help America's place on the global stage, or at home. And I know he says he's the most popular president in the most popular country since the dawn of time.
I'm a very stable genius.
But trust me, he's not. And going old school colonial on Greenland is not going to help. Anyway, back to the history lesson. In 1979, Greenland voted for greater autonomy from Denmark and to form its own government. And this is important. because Trump keeps talking about buying Greenland.
The fact that they had a boat land there 500 years ago doesn't mean that they own the land.
Denmark doesn't own Greenland anymore. Greenland owns Greenland. Us Danes even asked the Greenlanders how they feel about being bought.
300,000 kroner.
No, he could never buy us. Ever in my life, I would.
500,000?
No.
You see, we know the Greenlanders. They're a proud indigenous people who are not interested in being Americans. You can't just buy them off. So, Trump is running wild. He's kidnapping presidents, he's invading other countries without congressional approval, and frankly, we don't want that mess spilling into Greenland. Or Europe. Or Legoland, for that matter. So again, that's why we're trying to speak to the manager. But Congress still isn't picking up the phone. Hello?
My only criticism of this video, and I understand because you're part of the liberal media, so you are actually eternally cucked by Trump derangement syndrome, meaning you are so fucking afraid of criticizing one side because you don't want to be accused of having Trump derangement syndrome. The problem is not Congress. The problem is that the Republicans in Congress have abdicated their role as congressmen. They have decided that they don't have a job to do, and they're just going to let Trump do everything. That's the issue that we have right now. That's why Mike Johnson literally didn't even seat an elected Democratic congressman for, what was it, a month? Because they didn't want to take that fucking vote on the Epstein files. It ultimately, I guess, didn't fucking matter anyway because the FBI redacted 90% of the shit regardless. 1.5. Trump's Arctic commissioner shares that we could annex Greenland in weeks or months. He used to work in Russia and is a Russian expert, or a Russia expert. It's been 30 years since my early deal-making days in Moscow. It's fun to remember a time when we made 15x cash-on-cash returns for the U.S. government, building television networks in a newly independent Russia, and then selling them on to Russian oligarchs for $550 million. Yes, it happened. Why would you even admit this? Oh, okay, I don't know. Whatever. King.
2024.
Oh, we saw this. These are just links I've had open over the past couple days. New POTUS letter to Jonas Garstor links Nobel Prize to Greenland, reiterates threats, and is forwarded by the NSC staff to multiple European ambassadors in Washington. Dear Ambassador, President Trump has asked that the following message shared with Prime Minister Jonas Garstor, or Stur, be forwarded to your named head of government/state. Dear Jonas, considering your country decided not to give me the Nobel Peace Prize for having stopped 8 wars plus, I no longer feel an obligation to think purely of peace, although it will always be predominant, but can now think about what is good and proper for the United States of America. Denmark cannot protect that land from Russia or China, and why do they have a right of ownership anyway? There are no written documents, it's only that a boat landed there hundreds of years ago, but we had boats landing there also. I have done more for NATO than any other person since its founding, and now NATO should do something for the United States. The world is not secure unless we have complete and total control of Greenland. Thank you, President Donald J. Trump. Where is the, I think I have this open here. There was a stupid fucking video of Trump getting the, or no, it was of Macron. Does anybody know what I'm talking about? The call. Yeah. Bro.
What's going on?
Because he accepted what you proposed on you.
Sorry, hold on. I don't know. It's cut to 23 fucking seconds. 1 second.
Donald, I know it's very early in the morning for you. I'm sorry to call at that time. May I call you in 2 minutes with Zelensky, Starmer, and Merz? It's okay for you?
Yeah, go ahead. What's going on?
Because he accepted what you proposed on your on your message, meaning a ceasefire for 30 days and so on. So he's ready to announce it.
Did Putin accept also?
Yeah.
Oh, good. Nobel Prize for this.
So may I call you back with him and the others in 2 minutes? I call you back.
That's good.
Okay.
It's great news. Good. Call me back.
I'll call you back in 2 minutes with the others. I call you back.
You're the greatest. You are the greatest.
No, thank you.
He's such a fucking loser. God, he's such a fucking loser. Norway's PM response to Trump's message. Norway's position on Greenland is clear, obviously. I can confirm that this is a text message that I received yesterday afternoon from President Trump. It came in response to a short text message from me to President Trump sent earlier on the same day, on behalf of myself and the President of Finland, Alexander Stubb. He added, in our message to Trump, we conveyed our opposition to his announced tariff increases against Norway, Finland, and select other countries. We pointed to the need to de-escalate and proposed a telephone conversation between Trump, Stubb, and myself on the same day. The response from Trump came shortly after the message was sent. It was his decision to share his message with other NATO leaders. Norway's position on Greenland is clear. Greenland is part of the Kingdom of Denmark, and Norway fully supports the Kingdom of Denmark in this matter. We also support that NATO is in a responsible way. It's taking steps to strengthen security and stability in the Arctic, he continued.
Hey, my name's San Juan Dickel. I joined from the group page.
We're glad to see you here today.
Oh, this is crazy.
Hey, my name's San Juan Dickel. I joined from the group page.
We're glad to see you here today. And we've got Greg and Fat Nicker. Yeah, welcome. Well, we're just introducing ourselves. Hopefully I'm pronouncing your name right, Fat Nicker.
So are you referring to me?
Yes.
Oh, my name's Derek.
Hey, my name's San Juan.
Now, well, they got Tucker fired from Fox News, right? It doesn't matter. He's bigger. Yeah. He's bigger now. So what?
He's absolutely not bigger. You are delusional if you think that. Oh my God, these guys are so crazy. Oh my God, these guys are crazy. Tucker Carlson was on the largest cable news network in the United States. Was it every night or once a week? Like, oh, he was the largest. Maybe the largest news host in the world. Well, now it's probably like fucking India or whatever have fucking 10 billion people listening. But like, Jesus.
Now what are you going to do? And then Nick Fuentes, what are you going to do? He's banned off everything, you know? I mean, he's on, I guess, Twitter and Rumble. But so what are you going to do?
And he's huge.
He's bigger than ever, dude.
He may be bigger than ever. You had him on your show.
Yeah.
How was that?
I still think the height of Nick was his was the AFPAC that he got. It was Marjorie Taylor Greene and another senator, I think was the height, at least of the totality of his like influence and everything. Not this man, he'll get back there, I guess, if these guys keep glazing him. But
what is he like? Is he big or is he small?
He's not big. He's not a big guy. He's small. I mean, he's not like tiny, but he's not.
Somebody said he rides a bike. Guy. Is that true or not?
I did not see him on a bicycle. I can neither confirm nor deny. Huh. I believe he took an Uber to the studio.
Someone said he rode a bike to.
Oh, listen, I'll be honest. He told me he took an Uber to the studio. I did not see with my own eyes how he got there. He could have
not an Uber black.
He could. It was certainly an Uber white. No, you know, honestly, my impressions. I like Nick, and
he seems like a fascinating cat. I mean, he's obviously fascinating. He's fast. People are fascinated by him.
Well, he's brilliant, and he's hilarious. Which is already something that I just like that. I like funny people.
He's fucking brave, dude.
Well, he's definitely brave. And, you know, we have some pretty large areas of disagreement, I think. But I've always kind of believed okay, so then it's just, maybe this is kind of like a little naive or something. But my attitude was always like, all right, so we got some areas of disagreement. So like, hey, let's talk about them. And let's kind of let's have more conversations and more debates and more, you know what
sunlight,
I mean?
Sunlight is the best disinfectant. Sunlight is the best disinfectant, guys. A timely Soviet joke. A man comes to a newsstand every day, scans the front page, and leaves disappointed. One day, the vendor asks what he's looking for. The man says, an obituary. But, comrade, the obituaries are at the back. The man replies, not the one I'm looking for. Previously unknown documents from the Danish defense show that the Ministry of Defense and Denmark's top military leadership were concerned that the United States, informally and without involving Copenhagen, had attempted to persuade Danish counterparts in Greenland to hand over information about military installations, ports, and air bases in Greenland. The ministry was immediately informed out of consideration for the strategic climate in relation to Greenland. The same applied to the overall top leadership of the Danish defense, including the chief of defense. An expert says that we must expect American espionage against Denmark. I think you and Dave have some areas of disagreement. Do you think you'd want to talk about it? Dave is deathly fucking petrified of me. Dennis Villeneuve, I don't know how to pronounce this guy's last name, sorry. It says young people want longer films. Oppenheimer is a 3-hour rated R film about nuclear physics that is mostly talking, but the public was young. That was the movie of the year by far for my kids. There is a trend. The youth love to watch long movies because if they pay, they want to see something substantial. They are craving meaningful content. I hate the fact that you fucking losers think that Oppenheimer was a good movie. Oh my God. Oh, poll slop.
New polling ahead of the
midterm poll slop.
Democrats are feeling highly motivated.
Hold on one sec. Highly motivated.
To get out and vote.
The guy, this guy.
And that could be bad news for Republicans who are hanging on to a slim majority in the House. So let's go to CNN's chief.
Think they've gotten things done or not? 1 year in, Republicans feeling happy. Everyone else not as.
One of the things he said about feeling like Democrats aren't doing a good job at Congress. I think one of the hard things is like, what are you supposed to do? Like, there's really nothing. I don't even know what. Like, if Republicans are like, oh, well, we're not going to do anything, it's like, okay, well, we're the minority party, so.
So, Brian, the chairman of the Republican National Committee posted on X, quote, Republicans are going to defy history in November because there is nobody who can energize our base more than President Trump. And he linked to a Fox News headline that reads, RNC chairman bets on secret weapon to defy midterms history. What do you think? Is that...
Listen, sure, it's possible, but history is against us, right? And the economy right now appears to be against us. I think there's a recognition from this administration that they need to do more on the economy. You certainly have Vice President Vance and a lot of teams saying President Trump needs to be more focused on the economy. And there's an argument to be made on the economy. Inflation is lower, some gas prices, energy costs is lower. There's these things that they can be made, but it's getting lost.
I mean...
lost by the other topics that are taking place, so the international affairs. And my belief is if President Trump is out...
I also I think that... There's so many things I think. I wish I could fucking rewire all these fucking media people's brains. There needs to be clear questions of, hey, like, are you going to be happy in 1 year if XYZ happens? And then when it doesn't happen, you replay these clips over and over and over and over and over again, okay? How many times did we talk about prices are not going to come down? They're just not. You might be able to slow inflation down, but you're not going to bring the prices back down. Oh no, we're going to lower the cost, we're going to lower the price, we're going to lower the... And then as soon as he's elected, well, you see, it's not about bringing the price down. It's about changing the rate of change. All of a sudden, we had all of our calculus student Republicans came out of nowhere. It's like, well, you see, it's not actually about reducing the actual value itself. It's about the rate of inflation actually going down. And that's actually, and it's like, where the fuck were these? It's stupid.
Out there campaigning, highlighting the improvements that have been made on the economy, they make a stronger case than as opposed to him talking about Greenland or putting more tariffs on our European allies.
Yeah, I saw there was a graffito from New York that was on social media. It was something like, we don't want Greenland, we want healthcare. And Dan Pfeiffer, the former Obama communications director, said, not a bad message for the midterms.
Are you hoping impelled on the midterms? I mean, electorally, I'm pretty sure we're going to get a lot of wins. I think electorally we're going to do fine, but we have to exercise like an uncomfortable amount of power after we win the election. And I don't know if the will is there to do it. What is this? Is there going to be a video for this? Or I'm probably about to be banned from CNN, but someone has to say this about Scott Jennings. Julie Rajinsky? There are times you need to tell your friends that they are committing a grave mistake, even if they resent you for telling the truth. This is to say, I'm fairly confident that this column can be banned from CNN's airwaves. CNN's what sold itself to the grown up in the room, and the network. What am I? It's not about ideology. CNN has long and rightly made room for conservative voices. The problem is not that Jennings is a Republican. The problem is how he behaves, what he contributes, and what his presence signals about what CNN now tolerates. On air, Jennings does not debate, he blathers. He talks over women with particular frequency, interrupts relentlessly, and treats panel discussions as contests of volume and obstinacy rather than as exchanges of ideas. He mugs to the camera and rolls his eyes while calling any fact he does not like a lie. It is performative obstruction, the cable news equivalent of flipping the board when you're losing the game. This is not spirited debate. I mean, true, but this is all Republicans. This is all of them. This is all of, they do this on their own networks. They do this on Fox News. This is all they do. Like, there's no way you can defend anything in this administration. It's impossible. It's impossible. So, and yeah, it is cringe. It sucks. You can't, there is no good faith MAGA person. You can't, well, Stephen Miller, there are good faith ones, but they'll just tell you, like, yeah, we want to conquer the world. We don't care about rule of law. We are okay with an authoritarian dictatorship as long as he's our guy. Like, fuck everything. Fuck the Constitution. Fuck everything else. This is what he said.
I do love Hollywood.
Nice audio.
I do love Hollywood.
Do you consider yourself as you're like in showbiz now?
Yeah.
Yeah.
What I do is a mixture of showbiz and WWE.
Yeah.
And
you're a heel.
I'm a lovable rascal, but if you want to call it a heel, I do love Hollywood.
Like, the issue is that there's so many different moving parts and things that make this okay and not okay, and it's harder to there is a world of performativity here where if this is like the public, right? If we are the public and we are watching this spectacle and we see, you know, like the red and blue fighting with each other, and it might get a bit performative where they're saying things and it's kind of like, okay, we get it, like, whatever. There's like a bit of what he says, like the heel thing, you know, you're screaming at each other, whatever. But the difference is that back in the past, even though this public spectacle exists, Congress will come together, and at the end of the day, they will legislate. They'll do things, right? They might hate each other publicly, but they're working together privately. They're doing things to make sure that the government is functioning, and they're making compromises, and they're legislating as they're supposed to. But the problem is that now, it's no longer this shit. Okay? Now it's this shit. This is the thing. It's just this. Like, what we see publicly is what's happening privately. There is no more working together on anything. There is no more legislation. The Republicans have completely abdicated their role in Congress. They're not doing anything anymore. Breaking. Leaked video of Trump talking about Greenland to the rest of NATO.
No. No.
Okay. Okay. Man, what's going on, guys? It's a crazy world out here right now. Just a reminder, Republican legislators could end all of this literally whenever they wanted. True.
I am grow up. I'm 54 years old.
Well, no, you're not.
Yeah.
Doing this shit.
Are you a Trump supporter?
Yes, I am.
Can you tell me why you voted for Trump?
Because he's helping us out.
He's helping you out?
Yes, he
How is he
is.
helping you out?
Well, hell, he done lowering gas, gas down.
Does the president control gas prices?
Yeah.
How does he control gas prices?
Oh, bullshit. You're a fuck. You know what you are.
What am I?
Motherfucker.
Ooh, got him.
That's what you are.
I'm going to be nice to you. Actually, I was going to be nice to you until you called me that. But I think as a woman voting for Trump, You're a piece of shit? And is that your husband? He's a piece.
No, I'm her fucking I'm her son.
Oh, and you're a piece of shit, too.
Call me piece of shit.
You're a piece of shit.
Yeah.
Yeah.
It's okay. I'm ready to go to jail. I'm ready to put you in the hospital.
Punch me. Punch me.
I'm ready to put you in the hospital.
Do it.
Come on.
I do it.
Call my mom.
Do it. I'm right here. Come on, do it. Do it. Oh, you're a Trump supporter, too?
Call my mom something again.
Hey, your mom's a piece of shit.
You're a motherfucker.
Your mom, hey, and you're a piece of shit, too. That old lady said I was a motherfucker.
Uh-oh. Ooh. Hold on. r/Asmongold uncritically or unironically posting a Pearl clip from her Anna Kasparian debate. Bro, I was uncomfortable watching that. I feel like she was on something. Oh, I'm putting the wrong thing. Hold on one second. You have to see the clipping they do on it. Yeah, one sec. What is the... I'm normally logged into it's the Nathaniel Bonnell account. No, the Mr. Nathaniel account on this computer, right? Is what I was logged into before I reformatted it. Alright. I need to be familiar with this because it is a case that gets cited every now and then. I don't know the underlying facts though, so... This case was decided at the end of October, or I'm sorry, the end of 2024 in October. This was a Supreme Court decision. Is this just the syllabus or is it the whole thing? No, okay, it's the whole thing. It's a short decision. Barnes individually and as representative of the estate of Barnes, deceased versus Felix and others. Certiorari to the United States Court of Appeals for the Fifth Circuit. Argued January 22nd, 2025. Decided May 15th, 2025. Respondent Roberto Felix Jr., a law enforcement officer, pulled over Ashton Barnes for suspected toll violations. Felix ordered Barnes to exit the vehicle, but Barnes began to drive away. This is the syllabus, so there's going to be a summary of the case. So I'll read the syllabus, and then we'll read the, or this will be a summary of the case and the decision, and then we'll read the decisions. Felix ordered Barnes to exit the vehicle, but Barnes began to drive away. As the car began to move forward, Felix jumped onto its door sill and fired 2 shots inside. Barnes was fatally hit, but managed to stop the car. About 5 seconds elapsed between when the car started moving and when it stopped. 2 seconds passed between the moment Felix stepped on the door sill and the moment he fired his first shot. What is door sill? Is that like right in front of the car door on the side, I guess? Like right... Okay. Is there a video of this? Hmm. $2016, Jesus. Is this going to be super not safe for life, or? Oh, I guess it's on YouTube, so it is what it is.
Constable's Office. The reason you're being stopped today is because your vehicle alerted to outstanding tow violation. You have your driver's license proof insurance with you? Sir? I understand that, but it has outstanding tow violation. When did you rent the vehicle? About a week ago? I'm sorry, I couldn't hear you.
It's actually rented in my girlfriend's name. I'm on the way to get it washed and turn it back in.
Okay. What's her name? Okay. You have your driver's license?
Damn, you get pulled over for toll violations? What?
Anything that's different I need to know about? Okay. I'll go digging around. I smell marijuana. Is there any marijuana in the vehicle? Don't dig around. Don't dig around. Don't dig around. Okay. Do you have anything, any identification on you? Okay. Sure, go ahead and pop the trunk for me. Okay. Go ahead and put that paper off to the side for me. Go ahead and shut that for me. Don't fucking move!
Oh, shit.
Don't fucking move! Don't fucking move! Sure, go ahead and pop the trunk for me.
He doesn't shoot until he's already starting to get...
Go ahead and put that paper off to the side for me. Go ahead and shut that for me. Don't fucking move! Don't fucking move!
This is premeditated murder. That's the most retarded cop in the universe. I mean... It's hard because I can't see what's going on in the car, but... He wants him to step out. Like... Why did he have to step on the car? I don't know what my, I don't know what your gut reaction would be when you're already like this much inside of it. Like, I feel like this could go either way. Like, would your gut reaction be to like jump back, or would your gut reaction be with like, you've got the door pressing against you, you're already kind of inside. It almost looks like he's got a foot on the door sill or whatever. And then and then especially once this door closes. Oof. Yeah, I don't know. That's a... Time it takes for him to unholster his weapon is enough time for him to just get out. Yeah, but I don't know what why he takes the weapon out. I don't know if the guy's reaching for something or what's going on there. I'm not sure. But, okay. Okay, that's this video for this. Barnes' mother sued Felix on Barnes' behalf, alleging that Felix violated Barnes' Fourth Amendment right against excessive force. The district court granted summary judgment to Felix, applying the Fifth Circuit's moment of threat rule. The Court of Appeals affirmed, explaining that the moment of threat rule requires asking only whether an officer was in danger at the moment of the threat that resulted in his use of deadly force. Under the rule, events leading up to the shooting are not relevant. Here, the precise moment of threat was the 2 seconds when Felix was clinging to a moving car. Because Felix could then have reasonably believed his life was in danger, the panel held the shooting was lawful. So the district court ruled in favor before getting to trial. They granted summary judgment to Felix, the police officer, and then the decision was appealed up to the Fifth Circuit. And then that Court of Appeals also held it and then it seems like a writ of certiorari. So the Supreme Court to hear the case, it went up to the Supreme Court, and then they also hold on that the police officer was in the right here, I think is what this ultimate holding is. But okay. Held a claim that a law enforcement officer used... Oh, wait. Wait, I'm not misunderstanding this, am I? Right? To Felix. Right? I think I'm... Okay. Held a claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable force from the person or from the perspective of a reasonable officer at the scene. The inquiry into the reasonableness of police force requires analyzing the totality of the circumstances. That analysis demands careful attention to the facts and circumstances relating to the incident. Most notably here, the totality of the circumstances inquiry has no time limit. While the situation at the precise time of the shooting will often matter most, earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. Prior events may show why a reasonable officer would perceive otherwise ambiguous conduct as threatening or instead as innocuous. Another case well illustrates this point. There, an officer's use of deadly force was justified at the moment, partly because of what had transpired in the preceding period. The moment of threat rule applied below prevents that sort of attention to context and thus conflicts with this court's instruction to analyze the totality of the circumstances. By limiting their view to the 2 seconds before the shooting, the lower court could not take into account anything preceding that final moment. So, for example, they could not consider the reasons for the stop or the earlier interactions between the suspect and officer. Because of that limit, they could not address whether the final 2 seconds of the encounter would look different if set within a longer time frame. A rule like that, which precludes consideration of prior events in assessing a police shooting, is not reconcilable with the fact-dependent and context-sensitive approach this court has prescribed. A court deciding a use of force case cannot review the totality of the circumstances if it is put on chronological blinders. The court does not address a separate question about whether or how an officer's own creation of a dangerous situation factors into the reasonableness analysis. The court below never confronted that issue, and it was not the basis of the petition for certiorari. Vacated and remanded. Oh, so they rejected the lower court's decision, telling them that they need to engage in a different type of analysis, and then they remanded it to the lower court to consider that fact pattern. Gotcha. Okay. Okay. Fuck. This is why I hate getting summaries of court cases for other people. I understand. All right. Kagan delivered the opinion for a unanimous court, a 9-0 opinion. Kavanaugh filed a concurring opinion in which Thomas, Alito, and Barrett joined. Okay. Supreme Court of the United States. All right. Let me just start 1 sec, and then we'll read this. Okay. Justice Kagan delivered the opinion of the court. A police officer's use of deadly force violates the Fourth Amendment when it is not objectively reasonable, and that inquiry into reasonableness we have held requires assessing the totality of the circumstances. I wonder where they got this other standard from, moment of threat. The Fifth Circuit's moment of threat rule. Sounds like that's in conflict with the totality of circumstances that the Supreme Court is saying they need to use. Okay. Ugh. The question here is whether that framework permits courts in evaluating a police shooting or other use of force to apply the so-called moment of threat rule used in the courts below. Under that rule, a court looks only to the circumstances existing at the precise time an officer perceived the threat inducing him to shoot. Today, we reject that approach as improperly narrowing the requisite Fourth Amendment analysis. To assess whether an officer acted reasonably in using force, a court must consider all the relevant circumstances, including facts and events leading up to the climactic moment. That makes sense because, let's assume that, a guy pulls out a gun and you see the gun and you pull out your gun and you shoot him, you kill him. And at that moment in time, the moment of threat or analysis, you're like, oh shit, what are we going to do? And it's like, okay, well, reasonable. The guy pulled a gun on you. But let's say if you kill him, you find out, oh my God, it was just an airsoft gun. Oh no. And then, but you're like, well, the officer had a reasonable fear for his life, moment of threat analysis, whatever. But let's say that the officer was conducting an arrest or an investigation or something outside of an airsoft arena or something. And then a guy comes out with a gun and goes to shoot at the officer or whatever. Well, that assessment might look a lot different, right? It's like, well, did you really feel like he had a real weapon? Would a reasonable person have thought that? You're coming out of an airsoft arena, that might change the analysis. Not saying it would necessarily change your final decision, but a reasonable person might have a different perspective here, based on taking into account more circumstances, On the afternoon of April 28, 2016, Roberto Felix Jr., a law enforcement officer patrolling a highway outside Houston, received a radio alert about an automobile on the road with outstanding toll violations. Felix soon spotted the car, a Toyota Corolla, and turned on his emergency lights to initiate a traffic stop. The driver, Ashton Barnes, pulled over to the highway shoulder. Parking his own car just behind, Felix walked to the Corolla's driver's side door and asked Barnes for his license and proof of insurance. Barnes replied that he did not have his license with him and that the car was a rental in his girlfriend's name. As he spoke, Barnes rummaged through some papers inside the car, causing Felix to tell him several times to stop digging around. Felix also commented that he smelled marijuana and asked if there was anything in the car that he should know about. Barnes responded that he might have some identification in the trunk, so Felix told him to open the trunk from his seat. Barnes did so while also turning off the ignition. All that happened, as a dash cam recording of the incident shows, in less than 2 minutes. Then things began moving even faster. With his right hand resting on his holster, Felix told Barnes to get out of the car. Barnes opened the door but did not exit. Instead, he turned the ignition back on. Felix unholstered his gun and, as the car began to move forward, jumped onto its door sill. He shouted twice, "Don't fucking move," and with no visibility into the car because his head was above the roof, he fired 2 quick shots inside. Barnes was hit but managed to stop the car. Felix then radioed for backup. By the time it arrived, Barnes was dead. All told, about 5 seconds elapsed between when the car started moving and when it stopped. And within that period, 2 seconds passed between the moment Felix stepped on the door sill and the moment he fired his first shot. Barnes' mother, Janice Barnes, sued Felix on her son's behalf. The suit, brought under 42 U.S.C. Section 1983, alleged that Felix had violated Ashton Barnes' Fourth Amendment rights by using excessive force against him. The district court granted summary judgment to Felix. The court explained that to prevail on her claim, Mrs. Barnes needed to show that Felix's use of force was objectively unreasonable. In the usual excessive force case, the court noted, the inquiry into reasonableness would involve considering a variety of circumstances, but when an officer has used deadly force, the court continued, the Fifth Circuit has developed a much narrower approach. Then, a court could ask only about the situation existing at the moment of the threat that sparked the fatal shooting. The district court identified that moment as the 2 seconds before Felix fired his first shot, when he was standing on the doorsill of a moving vehicle. At that moment, the court found an officer could reasonably think himself at risk of serious harm, and under the Fifth Circuit's rule, that fact alone concluded the analysis. The court explained that it could not consider what had transpired up until those last 2 seconds, including Felix's decision to jump onto the sill. Although a more robust examination might have aided in assessing the reasonableness of the shooting, the court was duty-bound by circuit precedent to limit its focus to the exact moment Felix was hanging onto Barnes's moving car. Fuck, this is going to be really boring, I think. Is this just going to be rejecting that particular test? I have a feeling I feel like that's going to be what this course is about, or what this case was about. But we'll see. The Court of Appeals affirmed, explaining that it too was bound by this circuit's moment of threat doctrine. Under that rule, the panel agreed the inquiry is confined to whether the officer was in danger at the moment of the threat that resulted in his use of deadly force. Any prior events leading up to the shooting, including actions the officer took, were simply not relevant. And here, as the district court found, the precise moment of the threat was the 2 seconds when Felix was clinging to a moving car, because Felix could then have reasonably believed his life was in danger. The panel concluded his decision to shoot did not violate Barnes's constitutional rights. In a concurring opinion, Judge Higginbotham, who also authored the panel opinion, expressed concern with the Fifth Circuit's moment of threat doctrine. He thought that rule, inconsistent with the court's directive to assess the reasonableness of an officer's use of force, including deadly force, by looking at the totality of circumstances. Under the totality approach, Judge Higginbotham wrote, a court could consider not just the precise millisecond when an officer deploys force, but everything that had transpired up until that time. And with a wider focus, Judge Higginbotham would have found that Felix's shooting of Barnes was unreasonable. If he was using this wider thing, okay. We granted certiorari to address whether, in resolving Fourth Amendment excessive force claims, courts may apply the moment of threat rule just described. We hold they may not, because that rule constricts the proper inquiry into the totality of the circumstances. A claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment. The touchstone of the Fourth Amendment is reasonableness as measured in objective terms. So the question in a case like this one, as this court has often held, is whether the force deployed was justified from the perspective of a reasonable officer on the scene, taking due account of both the individual interests and the governmental interests at stake. That inquiry into the reasonableness of police force requires analyzing the totality of the circumstances. There is no easy-to-apply legal test or on-off switch in this context. Rather, the Fourth Amendment requires, as we once put it, that a court slosh its way through a fact-bound morass, or said more prosaically, deciding whether a use of force was objectively reasonable demands careful attention to the facts and circumstances relating to the incident. As then known to the officer. For example, the severity of the crime prompting the stop can carry weight in the analysis. That makes sense. So too can actions the officer took during the stop, such as giving warnings or otherwise trying to control the encounter. And the stopped person's conduct is always relevant because it indicates the nature and level of the threat he poses, either to the officer or to others. Most notably here, the totality of the circumstances inquiry into a use of force has no time limit. Of course, the situation at the precise moment of the shooting will often be what matters most. It is, after all, the officer's choice in that moment that is under review, but earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. Or, as the federal government puts the point, those later, in-the-moment facts cannot be hermetically sealed off from the context in which they arose. Taking account of that context may benefit either party in an excessive force case. Prior events may show, for example, why a reasonable officer would have perceived otherwise ambiguous conduct of a suspect as threatening, or instead they may show why such an officer would have perceived the same conduct as innocuous. The history of the interaction, as well as other past circumstances known to the officer, thus may inform the reasonableness of the use of force. The court's decision in Plumhoff v. Rickard illustrates the point. The excessive force claim there concerned the fatal shooting of a driver at the end of a dangerous car chase lasting more than 5 minutes. The driver had sped away from a traffic stop on a well-used road and tried to outrun as many as 6 police cruisers at speeds sometimes exceeding 100 miles per hour. Eventually, the fleeing car ran into one of the cruisers and came to a near standstill. The driver, though, still tried to escape, pumping the gas in a way that sent his wheels spinning and then putting the car into reverse. At that point, one of the officers fired several shots into the car, and a suit brought against the officer. The driver's daughter contended that those shots were taken when the chase was already over. But this court rejected that claim based on everything that had happened during the incident, the driver's outrageously reckless conduct or reckless behavior over the prior 5 minutes, as well as his last-second efforts to again take flight. What district court was this in? Hold on. Plumhoff v. Rickard. Richard? Sorry. No, Rickard. Is there not like an easy way to see where it came up through or whatever? Oh, 6th Circuit. Okay. Gotcha. Am I getting this wrong, or is this saying that if the officer, let's say, was filming on his own phone and walked willy-nilly in front of a vehicle, does count against him perceiving someone as a threat? We'll get to anything interesting in this case. Now I'm annoyed because I feel like I've heard this cited by a bunch of people over the past few days, but I'd have to go back and rewatch. But also, I'm not done reading this yet. All this is saying right now is that that police officer that we saw earlier killed the man that was driving his car. And when the district court considered this case, what the district court was using was a rule for the moment of threat, or the moment of threat analysis or whatever. That was the rule that they were using, meaning they could only consider what had happened at that precise moment when the threat began and then when the threat was terminated, for apparently when cops kill somebody. And then that was appealed up to the circuit, the 5th Circuit, and then the 5th Circuit held that. That's the rule. That's how they analyze things. And then it was appealed up to the Supreme Court. And now it sounds like the Supreme Court is saying, well, hold on. You can't use this moment of threat analysis. You need to use a totality of circumstances analysis. And that totality of circumstances is going to necessarily be much broader in terms of the facts that you consider when deciding whether or not it was a fair use of force by the police officers themselves, right? That's what this is saying. And it sounds like they're just rejecting one form of analysis in favor of another. Have the lower court re-ruled with this new direction? Considering this was a May ruling of, this year or something? Probably not, so... Okay, given all those events, the court explained, a reasonable officer would have concluded the driver was intent on resuming his getaway and, if allowed to do so, would again pose a deadly threat for others. In short, the shooting was justified at the moment it occurred, partly because of what had transpired in the preceding period. The moment of threat rule applied in the courts below prevents that sort of attention to context and thus conflicts with this court's instruction to analyze the totality of the circumstances. Recall that the District Court and 5th Circuit limited their view to the 2 seconds before the shooting, after Felix had stepped onto the doorsill of Barnes' car. Those courts believed that, under 5th Circuit precedent, they could not take into account anything preceding that final moment. So, for example, they could not consider the reasons for the stop or the earlier conduct of and interactions between the suspect and officer. And because of that limit, they could not address whether the final 2 seconds of the encounter would look different if set within a longer time frame. It is as though the court in Plumhoff could consider only the instant when the chased car was at a near standstill, and not the earlier time when it zigzagged down a busy roadway at speed. To be sure, historical facts will not often matter as much as they did there to the reasonableness analysis, and some of those facts may not be relevant at all, but no rule that precludes consideration of prior events in assessing a police shooting is reconcilable with the fact-dependent and context-sensitive approach we have prescribed. A court deciding a use of force case cannot review the totality of the circumstances if it is put on chronological blinders. That point is so evident that not even Felix quarrels with it. His defense of the decisions below instead relies on taking a different view of their meaning and of the question they raise. First, the agreement with what we have said. Yes, Felix acknowledges prior events are not off limits in the reasonableness inquiry, for they may inform the perspective of the reasonable officer. Just so, blah, blah, blah. Okay, but now the divergence. According to Felix, the courts below acted consistently with that all times considered principle. The Fifth Circuit's moment of threat doctrine, Felix argues, in fact allows courts to assess many pre-shooting facts and circumstances, and courts applying it often do so. All that the doctrine bars is a single kind of inquiry into whether an officer's earlier error itself created the need for deadly force. And on that issue, Felix submits the Fifth Circuit is right, An officer doesn't lose his rights to defend himself just because he previously made a mistake. But whatever might be said of Fifth Circuit law, generally, the decisions below applied a rule about timing. As shown above, both lower courts took pains to explain that, in evaluating the shooting's reasonableness, they could look only to a 2-second snippet of the encounter. And because that was the reasoning in the case before us, that is the reasoning we must address. It could make no difference to our decision here. The Fifth Circuit, in other cases, eschewed a strict time limit, as Felix claims. And anyway, we are not sure Felix correctly describes the overall state of Fifth Circuit law. Consider Harris v. Serpis, a Fifth Circuit decision relied on below. The court there noted the plaintiff's recital of several historical facts, actions of both the suspect and the officer in the period prior to the shooting. And the court recognized that this court's decision directed an inquiry into the totality of the circumstances, but then came the following, quote, "This circuit, however, has narrowed that test," end quote, in deadly force cases, holding that the inquiry there is, quote, "confined to whether the officer was in danger at the moment of the threat that resulted in the officer's shooting," end quote. The problem with the statement is apparent. As we have explained, a court cannot thus narrow the totality of the circumstances inquiry to focus on only a single moment. It must look to, in this and all excessive force cases, at any relevant events coming before. We do not address here the different question Felix raises about use of force cases, whether or not an officer's own creation of a dangerous situation factors into the reasonableness analysis. As in another of our recent Fourth Amendment cases, that issue is not properly before us. The courts below never confronted the issue, precisely because their inquiry was so time-bound. In looking at only the 2 seconds before the shot, they excluded from view any actions of the officer that allegedly created the danger necessitating deadly force. So, to use the obvious example, the courts below did not address the relevance, if any, of Felix stepping onto the doorsill of Barnes's car. Because they never considered that issue, it was not the basis of the petition for certiorari. The question presented to us was one of timing alone, whether to look only at the encounter's final 2 seconds, or also to consider earlier events serving to put those seconds in context. With that matter resolved, we return everything else to the courts below. It is for them now to consider the reasonableness of the shooting using the lengthier time frame we have prescribed. Accordingly, we vacate the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion. When a case is remanded like this, is the case remanded all the way to the lowest court? Or is the case remanded to the lowest fact-finding court? Or is it just going back to the Court of Appeals? It must go back to the lowest court it was tried, right? Because they have to do fact-finding again, or they might present different facts, I would imagine, right? Yes, I have no fucking idea. And then I imagine they would have to do another trial, right? Would they have to redo the whole trial and see what the jury finds? Well, here there's not a trial to redo because it was granted on summary judgment, I guess, so. Okay. And then Kavanaugh, what does he write here? Thomas, Alito, and Barrett all join, so all the conservatives join him with his concurrence. I join the court's opinion. I agree that the officer's actions during the traffic stop in this case should be assessed based on the totality of the circumstances. I write separately to add a few points about the dangers of traffic stops for police officers, particularly when, as here, the driver pulls away in the midst of the stop. Even for routine traffic violations, traffic stops are fraught with danger to police officers. An inordinate risk confronts an officer as he approaches a person seated in an automobile. That is, in part, because officers operate at a tactical disadvantage when approaching an unknown vehicle with limited visibility and unpredictable threats. As this court noted nearly 50 years ago, a significant percentage of murders of police officers occurs when the officers are making traffic stops. Traffic stops remain highly dangerous today. On April 8th, 2023, 2 officers were shot and killed at an intersection in Cameron, Wisconsin after stopping a car for a warrant and welfare check on the driver. On December 8th, 2024, an officer was shot and killed once after he pulled over a pickup truck with expired license plates in a Super 8 motel parking lot in Terrell, Texas. The list goes on and on. Officers cannot let their guard down and assume that any particular traffic stop will be safe, even if a driver is pulled over for nothing more than a speeding violation, a broken taillight, or the like. The driver may be drunk, on drugs, armed, or some combination thereof. Or the driver may have committed, or may be about to commit, a serious crime. People detained for minor offenses, such as ordinary traffic violations, can turn out to be the most devious and dangerous criminals. Timothy McVeigh, the man responsible for the 1995 Oklahoma City bombing, was stopped for a missing license plate, which ultimately led to his apprehension for the bombing. Likewise, serial killer Ted Bundy was pulled over based on a stolen vehicle alert in Pensacola, Florida. When informed that he was under arrest, Bundy kicked the officer's legs out from under him, and the two struggled over the officer's gun before the officer was able to subdue and arrest Bundy. So even though most traffic stops end without incident, traffic stops are nonetheless inherently risky for police officers. And when, as in this case, the driver suddenly pulls away in the midst of a stop, the risks multiply. A driver speeding away from a traffic stop could easily endanger bystanders and other drivers, especially if the fleeing driver is under the influence of alcohol or drugs, as might as well be the case when a driver flees. Moreover, the very fact that a suspect flees when suspected of a minor offense, such as speeding or a failure to pay tolls, could well be indicative of a larger danger. Fleeing from the traffic stop could suggest that the driver is preparing to commit or has committed a more serious crime and is attempting to evade detection or arrest. The driver may have illegal drugs or an illegal gun in the car. I feel like we need some evidence of this, or the driver may be unlawfully in the country and fear removal if apprehended. He might have a warrant out for his arrest. He could have an abducted child in the car. Or, as the tragic 2025 New Year's terrorist attack on New Orleans illustrates, the driver might intend to use the car as a weapon. The possibilities are many, but the key point is a common sense one. A driver who speeds away from a traffic stop can pose significant dangers to both the officer and the surrounding community. The question when a driver flees, therefore, is not merely whether the underlying traffic violation presents risks to public safety. This is a crazy standard, because this suggests that Kavanaugh and the other four conservatives here would say that every single time somebody flees any kind of traffic stop, that they could just be killed for it. That's what this is suggesting to me. But I don't know. I feel like that's a little bit wild to me, but it's Kavanaugh plus three others. What was it? It was Kavanaugh, Thomas, Barrett, Alito. Was it just, oh wait, was it anybody else? Kavanaugh, Thomas, Alito, and Barrett. Oh, just four, sorry. Fleeing with a vehicle is considered to be a violent felony, so yes. What? Link me that. Okay, where am I? Was there many? One is common sense one. A driver who speeds away from a traffic stop. Okay. The question when a driver flees, therefore, is not merely whether the underlying traffic violation presents risks to public safety. It is also whether flight and what that flight might indicate or enable does so. In those circumstances, in other words, it is not only the severity of the crime that prompted the stop that is relevant to the totality of the circumstances inquiry. The Fourth Amendment analysis must also take account of the suspect's attempt to evade the officer by flight. What should the officer do when a driver flees from a traffic stop? There are no easy or risk-free answers. Every feasible option poses some potential danger to the officer, the driver, or the public at large, and often to all three. And an officer in that situation must make a split-second choice among those various dangerous options. I'm sorry, okay. First, the officer could simply let the driver go, but because the fleeing driver might be a threat to the community, letting the driver go may exacerbate the dangers rather than mitigating them. Encouraging officers to stand back and allow drivers to take off would also create perverse incentives for those who are stopped by the police. If doing nothing in response to a fleeing driver became a known and regular practice among police officers, that would presumably embolden some drivers who otherwise might have thought twice about taking off. Of course, the officer could let the driver go in the moment, but then attempt to catch the driver by, for example, tracking the car's license plate or reviewing surveillance footage. But after letting the driver go, the police may not be able to later track down the car or the driver of the car, even if the police are, I hope he does two sides. I feel like sometimes when Supreme Court justices are like, when they really feel strongly about an argument, they never analyze the other side of the argument, right? Like, The other side of this is if you say you can just execute anybody driving by, might encourage behavior from police officers where there's always like, from now on, like the new meta, I don't know if this happens in GTA RP or whatever, right? Like the meta is to just stand with like your hip in front of the car so that they start driving at all. You can always just shoot and kill the person, right? Which is probably not, you wouldn't want that to happen either, right? Even if the police are able to do so, the escaped driver may pose a serious risk to the public in the interim. And given that the driver has already shown a propensity to evade law enforcement by fleeing a traffic stop, attempting to execute an arrest upon finding the driver could itself be dangerous for the police and others. Second, the officer could get back in his police car and give chase, or could radio other officers to pursue the driver. But a high-speed chase, likewise, can be exceptionally dangerous to the officer, the driver, and others on the road. Vehicular pursuits are often catastrophic. Many real-world examples demonstrate as much. Plumhoff v. Rickard involved a dangerous car chase in which the driver tried to outrun as many as 6 police cruisers at speeds sometimes exceeding 100 miles per hour, ending in the fatal shooting of the driver. In Scott v. Harris, multiple police cars, with blue lights flashing and sirens blaring, chased the driver for nearly 10 miles while he ignored their warning to stop, culminating in an officer ramming the driver off the road. Moreover, a recent study concluded that a significant percentage of those killed in police chases are not the fleeing drivers, but rather are passengers or bystanders. From 2017 through 2020, more than 500 bystanders were reportedly killed as a result of police chases. Third, the officer might try to shoot out the tires of the fleeing car or otherwise try to hinder the car's movement in order to bring it to a stop, but shooting at a car, especially its tires, can be dangerous and is often ineffective. Even if the officer manages to hit the tires, the driver could lose control and crash into others on the road. That course of action also poses the risk of the officer accidentally shooting the driver or innocent passengers. Fourth, as happened here, the officer could attempt to stop the fleeing driver at the outset by jumping on or reaching into the car. The dangerousness of that option is readily apparent. Jumping on the car stops the fleeing. What? Perhaps the driver will hit the brakes once he realizes an officer is clinging to the car or attempting to reach through the window. But if the driver does not slow down, then the officer may suffer serious and perhaps fatal injuries. The officer could try to fire his weapon to incapacitate the driver and bring the car safely to a stop. But the car may be just as likely to go careening into traffic, thereby threatening the safety of the officer, other drivers, passengers, pedestrians, and more. That could go on. The point here is that when a driver abruptly pulls away during a traffic stop, an officer has no particularly good or safe options. None of the options available to the officer avoids danger to the community, and all of them require life or death decisions that must be made in a few seconds in highly stressful and unpredictable circumstances. Of course, when an officer uses force against a fleeing driver, the judiciary still must assess any resulting Fourth Amendment claim under the standard of objective reasonableness. I feel like one training thing or policy thing here would be if you ever think you're going to have to shoot at somebody for fleeing, like if the circumstances have reached that threshold, then I feel like you should just tell the driver to get out of the car. And then if they don't, then maybe that can inform the analysis going forward. But at that point, if you're going to kill them if they flee, I feel like there should be something where it's okay, well, you need to get out. I don't know. But this seems, whatever. It's the conservatives. It's always a one-sided analysis with them, I guess. Under this court's precedents, that inquiry involves a careful balancing of the nature and quality of the intrusion on the individual's Fourth Amendment's interests against the countervailing governmental interests at stake. In conducting that analysis, judges should keep in mind that it is one thing to dissect and scrutinize an officer's actions with a 20/20 vision of hindsight in the peace of a judge's chambers. It is quite another to make split-second judgments on the ground in circumstances that are tense, uncertain, and rapidly evolving. In analyzing the reasonableness of an officer's conduct at a traffic stop, particularly traffic stops where the driver has suddenly pulled away, courts must appreciate the extraordinary dangers and risks facing police officers and the community at large. Well, I don't know how I feel about this concurring opinion. I feel like it was kind of inappropriate. I feel like, especially this type of analysis, seems like it would be some of the most well-suited stuff for individual districts and circuits to kind of develop their opinions on. Well, or maybe not, since it involves the Fourth Amendment. Maybe not. I don't know. Just not too sure why this needed to be here. It's Thomas posting. Well, this was Kavanaugh writing, though. The Fifth Circuit test was stupid, though. Yeah, I agree. They could shoot down some stupid tests, but which apparently they did. I just don't know why Kavanaugh opined so much here on how the lower courts should engage in their analysis that they haven't even engaged in yet. I just don't understand that. How do you think this affects the Renee shooting? I mean, any additional analysis is going to severely hurt the police officer's chances on the Renee shooting. The Renee shooting people would very much, and you've seen this with people, I've debated and other people, the Renee shooting people would very much like that Fifth Circuit thing, that moment of threat rule, because all of them argue, well, he looked, she was turning the wheel and the car started, he was about to run her over, right? That's the only analysis they want to go towards. The expansion to any type of totality of circumstances, this is a large lesbian lady in her car, like no violent thing has happened yet. It seems like the officer's walking around the car. It seems like it would hurt the officer's argument. But that guy's never going to be charged with a crime because this federal government is insanely corrupt. So why not help establish the procedure for lower court analysis? My understanding is that generally that's not the job of the Supreme Court. The way that our federal court system is thought up is that all of the other courts kind of like figure their stuff out, and then the kind of like standards that develop percolate up through the circuit courts, and then maybe something will get to the Supreme Court, and then maybe there'll be like a broader thing issued. But generally it's the lower courts that start to develop these kinds of legal tests, and then they're tried through multiple cases, and then all the case law kind of develops, and then maybe something's appealed up to a circuit, and then the circuit, a court of appeals, can take an analysis of different cases and consider things, and then maybe if the Supreme Court feels like they need to hear the issue, it'll go up to them. But better for, I guess, there are a common law system or whatever, right, that you have these cases that are tried and the rules that are tried, and then you kind of see how it works through the variety of cases that are brought to all of the district courts and then appealed up to the circuits. Yeah. Didn't the Supreme Court write the rules regarding abortion in Roe? I don't think they waited for that to percolate. I don't know all of the underlying case law that underpinned that, so I can't say. I didn't. Yeah. Is this for state police only, or does this extend to federal too? This would probably extend to anybody that's a police officer that could kill you. It's a Fourth Amendment analysis. That would apply to everybody except for the President of the United States if he wanted to kill you, because the Supreme Court thinks that the president can commit no crimes. But for everybody else, yeah. Wait, there's no way this is real, right? The DOJ to charge Don Lemon under the KKK Act for inciting church raid. What is this church raid thing that I've heard? Did this happen today or yesterday? Yesterday, they barged into a church in St. Paul because the pastor was an ICE tutor in Minnesota. I don't know anything about it. I don't know if I want to read this or not. I'm feeling lazy now. America's own goal. Who pays the tariffs? Kiel Policy Brief. Kiel Institute for the World Economy. Overview. The 2025 U.S. tariffs are an own goal. American importers and consumers bear nearly the entire cost. Foreign exporters absorb only about 4% of the tariff burden. The remaining 96% is passed through to U.S. buyers. Using shipment-level data covering over 25 million transactions valued at nearly $4 trillion, we find a near-complete pass-through of tariffs to U.S. import prices. Really? Isn't it supposed to balance out to about 50-50? Maybe the markets haven't had time to settle? U.S. customs revenue surged by approximately $200 billion in 2025, a tax paid almost entirely by Americans. Even studies around discrete tariff shocks on Brazil and India confirm export prices did not decline. Trade volumes collapsed instead. Oh, okay. This is what you would expect to see for kind of a sharing of the tariff burden. But that's bad. That's really bad if that's true. Indian export customs data validates our findings when facing U.S. tariffs. Indian exporters maintained their prices and reduced shipments. They did not eat the tariff. Damn. Question of tariff incidence is not new. During the 2018-19 U.S.-China trade war, a substantial body of research emerged documenting who bore the costs of those tariffs. The consensus was striking. U.S. import prices rose nearly 1-for-1 with the tariffs, while Chinese export prices remained largely unchanged. Ouch. Okay, well, damn. I was not aware of that, assuming what he's saying is true. Studies using detailed product-level data found pass-through rates close to 100%. Meaning American buyers paid essentially the full amount of the tariff. Chinese exporters, despite facing significant new trade barriers, did not cut their dollar prices to maintain market share. Instead, the primary adjustment occurred through reduced trade volumes. Fewer Chinese goods entered the United States, but those that did were not discounted. Why do you think it would balance out to 50-50? All other markets that were previously present are not burdened by the tariffs. Sellers will sell more to them. Why do I think it would balance out to 50-50? Well, if the American market is substantially larger than the rest, then that would be my assumption. And I don't know, I've repeated it because I've heard it said before that eventually tariffs, I thought that was studies, I thought they had looked at tariffs in the past, and I feel like I read some NBER paper that like had that in a sentence, but I don't know, maybe that's not true. Don't ever read this slop from people on X unless they're like high-level celebrities or like high-level people that you know of, like you know they're a real person. I would treat all of these like they're just bot accounts, or if they're not bot accounts, they're people that aren't worth reading anything from. The whole goal of this platform is to just make you upset and pissed off. It's not even to convince you of a thing to be true. Like most of the posts here are just so obviously low IQ and stupid. And again, especially when you see these fucking dollar sign thing, I don't know. I don't ever believe these people are real. He might be real, but you can treat him like a bot. His opinion isn't relevant. He's a worthless human being. Like, why? Nothing he says is going to be of value to any of this. Like, don't ever get mad reading this stupid shit. Cake, yeah, but it's at the command issuer, so it doesn't mean we need to trigger it. What are we triggering? Okay. The finding was initially surprising to some observers. Standard economic models suggest that the incidence of a tariff depends on the relative elasticities of supply and demand. If foreign exporters face highly elastic demand, meaning buyers can easily switch to alternatives, they might be expected to absorb part of the tariff to remain competitive, but the 2018 to 2019 evidence suggests otherwise. Maybe there were no easy substitution goods? Maybe. Several explanations emerged. First, for many products, there were no close substitutes readily available from non-tariff sources. That's a big one too, non-tariff sources, because we tariffed everything too. Maybe that made it harder. Respond to my follow-up, Destiny. What? Additional costs will be eaten by those who can eat it. If a seller's a 500% markup, they will eat the additional cost. If the markup was 1%, buyer has to eat all additional costs. Okay. Second, Chinese exporters may have faced capacity constraints that limited their ability to redirect sales elsewhere. Third, and perhaps most importantly, the structure of global supply chains meant that many U.S. importers had already optimized their sourcing could not easily switch suppliers in the short run. The 2025 tariffs provide an opportunity to test whether these patterns hold at a much larger scale. The Liberation Day tariffs were broader in scope, higher in magnitude, and applied to a wider range of trading partners. Our findings confirm that the same dynamics apply near complete pass-through to U.S. buyers. Damn. Validation. Brazil and India case studies. Our baseline estimates capture the average effect of tariffs across all products and countries, but averages can mask important heterogeneity, and identification relies on the assumption that tariff changes are not correlated with other factors affecting prices. To address these concerns, we conduct event studies around discrete, well-identified tariff shocks. We focus on 2 countries that experienced sharp sudden tariff increases in August of 2025, Brazil and India. I'm confused. Do consumers eat the tariffs or no? My understanding is that general economic thought is that over time, the exporters will try to lower their prices in some way or eat the cost in some way, such that it's basically like 50-50. Consumers and exporters, importers and exporters both bear about 50% of the cost of tariffs. But according to this, basically 100% of the tariffs are being passed through to U.S. consumers, and there is no reduction in price from the exporter. The only difference is we're just buying less, but still at like an increased price, and we're basically eating 100. Like the consumer is apparently eating basically all of the tariff. Brazil, the 50% tariff shock. On August 6, 2025, the U.S. imposed a 50% tariff on imports from Brazil. This was a sudden and substantial increase affecting a wide range of products. We estimate the dynamic effect of this tariff using the Sun and Abraham interaction weighted estimator, which addresses potential biases from staggered treatment timing and heterogeneous treatment effects. Heterogeneous? It's heterogeneous, right? I think. Figure 2 displays the results. X-axis, we several figures sent out. First, the pretreatment coefficients are centered near 0 and show no systematic trend. This supports the parallel trends assumption underlying our difference in differences design. Absent the tariff, Brazilian import prices would have evolved similarly to the control group. Second, and most importantly, the post-treatment coefficients remain close to 0 and statistically insignificant. Following the imposition of a 50% tariff, Brazilian exporters did not substantially reduce their dollar prices. The estimated coefficients hover around 0 with confidence intervals that exclude economically meaningful price reductions. This finding confirms our baseline results in a cleaner setting. Brazilian exporters did not eat the tariff. The burden of the 50% tariff was passed through nearly in full to U.S. importers. And then India, sounds like apparently this did the same. India offers something Brazil does not: detailed export customs records capturing FOB, free on board, prices at the port of departure. This data source is invaluable because it eliminates potential confounds. If Indian exporters were absorbing part of the U.S. tariff, we would expect to see their U.S.-bound prices fall relative to shipments destined for other markets, Europe, Canada, Australia, that did not face tariff increases. This is precisely what we test. The pattern is striking. Export unit value to the U.S. remained unchanged relative to other destinations. The volume effects, however, were substantial. Export values to the U.S. fell by approximately 18 to 24% relative to other destinations. And quantities fell by similar magnitudes. Indian exporters responded to U.S. tariffs by shipping less, not by cutting prices. They adjusted on the quantity margin, not the price margin. Well, why don't exporters absorb tariffs? A natural question arises. Why don't foreign exporters cut their prices to maintain access to the lucrative U.S. market? Several factors help explain this pattern. Alternative markets exist. The U.S. is a large market, but it is not the only market. Exporters facing U.S. tariffs can redirect their sales to Europe, Asia, or other destinations. Redirecting sales is feasible. Exporters have less incentive to cut prices, specifically for U.S. buyers. The Indian export data confirms this. Indian exporters maintain their prices across all destinations, suggesting they were able to find alternative buyers for goods no longer competitive in the U.S. Cutting prices may not help. Even if an exporter cuts prices, a 50% tariff is extremely difficult to overcome through price concessions. True. An exporter would need to cut their price by 1/3 just to offset a 50% tariff, a margin cut that would likely be unprofitable for most firms. Given the choice between maintaining margins or on reduced sales or slashing margins to maintain volume, most exporters apparently prefer the former, which makes sense. Expectations matter. If exporters believe tariffs may be temporary or subject to negotiation, they may have less incentive to make costly price adjustments. Cutting prices in response to tariffs could set a precedent that invites further tariff increases in the future. And supply chains are sticky. Many U.S. importers have longstanding relationships with foreign suppliers and cannot easily switch to alternative sources. Well, consumers are the ultimate bearers of the burden. Whether through higher prices on imported goods, higher prices on domestically produced goods, They use imported inputs or reduced availability in a variety of products. American households pay for the tariffs. The $200 billion surge in customs revenue is not free money. It comes from American wallets. The economic cost, moreover, exceeds the tariff revenue collected. Tariffs distort consumption patterns, leading consumers to substitute towards less preferred but non-tariff alternatives. They disrupt supply chains, forcing firms to bear adjustment costs, and they reduce the variety of goods available to consumers. These deadweight losses are pure economic waste, costs borne by Americans with no offsetting benefit. Welp. Okay. Based. Jesus. What?
So we are doing everything we can and should do as a good ally of the Americans.
Would this essentially be a VAT? No, because it's only selectively applied to some goods at like random varying rates that change every time the president wakes up and has a new fucking idea or whatever. It's retarded.
As a good ally of the Americans.